SJC-13309, Commonwealth v. David J. Pond.
Okay. Attorney Trett.
That is correct, Your Honor. Good morning. Good morning, Madam Chief Justice. It may it please the Court. Konstantin Tretyakov, Special Assistant District Attorney on behalf of the Commonwealth. Before I start, I also wanted to mention that the alleged victim in this matter has been made aware of the oral argument today. She could not be here, but she supports the Commonwealth's argument in this case. Both the decision of the motion judge, who treated Rule 17 as a discovery tool in this case, and the decision of the single justice, who ignored the systemic implications of this case, were abuse of discretion and should be reversed. In this case, the defendant initially filed a motion to inspect the crime scene, which the motion judge allowed. During the hearing on that motion, defense counsel represented that she wanted to inspect the residence of the alleged victim, specifically the kitchen, the hallways, the doorways, the driveway, the living room, and the dining room. The Commonwealth objected to that on the basis of relevance and on the basis of alternative means to present defense counsel with that information to prepare it for trial, but the motion judge allowed the motion, saying, I quote, "There is really nothing that can substitute for the defense counsel's eyes on the crime scene." A month after the motion was allowed, defense counsel visited the residence and was granted access to exactly the areas that she was asking for during the motion hearing. But as they say, appetite comes with eating. And she wanted also to access the two bedrooms. One is the victim's bedroom, and the other one is the bedroom that the defendant used to occupy, and the bathroom inside the victim's residence. And she was not allowed to do that because that was beyond the scope of the initial motion.
Can I just ask a question? So if the judge said there's no substitute for actually seeing, right?
Yes, Your Honor.
Why is that not the answer for the additional areas that that they wanted to take a look at? Isn't that the answer? They needed to see the areas? I understand that there were more things that they wanted to see after that, but...
That is correct, Your Honor, but these areas have nothing to do with the scene of the crime. Under Mattis and under all Rule 17 cases that I have read, the objects, the documents, the papers, the books, they have all been relevant to the crime itself.
Well, was there enough concern that there might be these prior bad acts that allegedly took place in the bathroom and the bedroom, though?
Your Honor, the Commonwealth, again, we reiterated that position multiple times. We have no intention to introduce these bad acts in our case in chief. If the defendant opens the door to that on cross-examination, or in his case, that can be a different story, but we have no intention to do that.
I think we probably should hit the reverse button, though, because we're at the merits of the issue, and you got the first hurdle as to whether or not the single justice even needed to reach the merits, and we really haven't talked about that.
Yes, Your Honor, happy to address that. The issue concerns, there are three, I would say, systemic implications with respect to this case. One is irreparable violation to the victim's privacy, and it also goes to the third prong under Fontanes, the chilling effect on the Commonwealth's cases, because if the ruling is allowed to stand, and if defense counsel will be allowed, as she was in this case, unfettered access to all rooms and curtilage of the residence of the victim, even the areas that the defendant was not asking for the access.
Escorted to the premises with an officer?
Yes, the judge ordered the police officer to be present, but that does not in any way mitigate the intrusion of the constitutionally protected reasonable expectation of privacy that the victim has in her residence. And
Was the defendant able to go? Did the defendant attend?
No, Your Honor. The defendant was not in attendance.
So the defendant wasn't there. How is this any different than a jury taking a view of a scene of a crime, such as a home where something happened inside?
That motion would be subject to the discretion of the trial judge. There would be no commentary. There would be no inspection of the scene, no taking photographs, no taking measurements. It will be an impartial finder of fact just taking the view under Section 1109 and of Mass Guide to Evidence, no commentary would be allowed. The judge would be present during the view. This is different because if we may go back to the issue of relevance that Chief Justice Budd mentioned, the defendant justified the intrusion into the victim's residence based on the prior bad acts. But as this court repeatedly said, most recently I think in the Jones case decided in 2017, the proponent of the evidence, the moving party, must establish the evidence that they seek to admit before the motion judge under Rule 17. In this case, the defendant mentioned prior bad acts that happened at some unspecified point in the past. The victim and the defendant started dating in 2003 and stopped in 2021 after this horrific incident that we allege has occurred. That's 18 years of relationship. Defense counsel said that at some point during that relationship, there were these prior bad acts that he committed against the victim, and the victim was making prior inconsistent statements about them. We have no idea when they happened. Was it 5 years ago, 10 years ago, 15 years ago?
So it's not that this isn't an important issue and that we shouldn't be chatting about it, but I'm sorry, I'm still stuck back on prong
Absolutely.
one here about extraordinary circumstances.
Absolutely, Your Honor. So what happened in this case is that the ruling of the motion judge, she failed to consider the reasonable expectation of privacy of the...
But I think what Justice Lowy, and I apologize for interrupting you, but I think, well, at least my question is, why did the single justice abuse his discretion in not allowing the appeal of the allowance of the motion?
Your Honor, because there are several systemic issues that are involved in this case. One is, and this is what we argue towards the end of our brief, the constitutional implication of Mattis. Because what Mattis left undecided is when you have a state-sanctioned and state-directed search of a private residence, which constitutes, for all intents and purposes, of state action, and the search occurs in a constitutionally protected area, the Fourth Amendment and Article 14 require probable cause for that search. And currently, the Rule 17 protocol for when the search occurs in a constitutionally
So
protected...
you're saying the victim's Fourth Amendment right is being violated by allowing entry by defense counsel into her bedroom?
Without establishing probable cause and without
But the
establishing...
cause for
kitchen
what?
is okay.
Pardon me, Your Honor?
Probable cause for what?
Probable cause, the nexus between the allegations, what evidence the defendant seeks to find there, and what he seeks to prove.
I'm sorry.
Where's the state action?
It's court-directed search, Your Honor. Under Mattis, the court has to carefully craft the order for the inspection of the crime scene. The court should provide, under Mattis, who may have access on behalf of the defendant, when access may occur, for how long the access should be there, what people, what additional individuals are permitted to be. That's directing
So
the
the
search.
Fourth Amendment doesn't protect against all searches, just unreasonable searches. Why is it unreasonable to allow the defense counsel to enter into the crime scene area beyond what the Commonwealth is immediately alleging?
Your Honor, one, searches under the warrantless searches under the Fourth Amendment are all presumptively unreasonable, and the party who wants to do the search bears the burden of establishing the reasonableness.
Well, and you've got a difference with regard to a residence, don't you? But you wouldn't, you normally don't have a reasonableness standard for searching a residence. You usually have to go in through a warrant.
Correct.
So, but in this case, you're saying there's no probable cause
Yes, Your Honor.
and that there would have to be a warrant?
Your Honor, there would have to be a demonstration of probable cause to enter the areas of the relevance of the residence, which have no
And the only areas
relation.
we're concerned about are the bedroom, the secondary areas, not the first areas.
Correct. The bedrooms and the bathroom that, again, the defense counsel conceded that during the second motion hearing. They have no relation whatsoever to the crime. They're only related to a collateral matter. The alleged prior bad acts. And in all rules...
I am one step behind Justice Cipher, as I always am. What probable cause to believe what?
to believe that the evidence, the nexus that the evidence found in those areas would be relevant to what the defendant seeks to prove.
And that
by
comes
accessing
from
those. It's not different from
Matz's.
probable cause that we have to establish.
Well,
in
it
that way.
is, because the probable cause that you have to establish, as you say, is that a crime is being committed.
Correct. And the defendant is alleging that certain acts have occurred, and the evidence that he seeks by entering those premises would be found in those premises.
The alleging crimes occurred?
No, but she is alleging these prior bad acts.
So you would elevate prior bad acts to the status of requiring a warrant?
Your Honor, not.
Prove a prior bad act?
I'm sorry, I may have misspoken. In this case, we would argue that the access to the bedroom and the bathroom should not have been granted in the first place, because they have nothing to do with the crime whatsoever.
Okay.
So if you were to have been more focused on the opposition to the Mattis motion in your pleadings, you would be focused on the second search only.
Correct. And that is the only second search that we are appealing from. We did object to the first search that was confined to the actual scene of the crime. The kitchen, the dining room, the living room, the doorways, the hallway, and the driveway. And defense counsel had access to that. Then she decided, sua sponte, I guess, to expand the scope of that. I wanted to go to the bedroom, the second bedroom, and the bathroom, where the victim undisputedly have a reasonable expectation of privacy in her residence. I don't think there can be any debate about that, respectfully. And then, that showing that what the defendant failed to do is, A, to demonstrate relevancy, because it was allegedly connected to some prior bad acts that occurred God knows when in the past. And if they happened long ago, what relevance, if any?
But let's remember what you're arguing right now for a minute, because I am still on whether there's extraordinary circumstances such that Justice Gaziano needed to reach the merits. And you're arguing, the reason you got into this argument is you're saying because, number one, there's a systemic concern about defense attorneys going into private homes as it relates to a constitutional issue.
Without establishing relevance, and under the motion that was treated as a fishing expedition and not as a rule of production.
That
Yes.
you thought that there were extraordinary circumstances here.
Your Honor, well, the constitutional implications of Mattis, we have discussed that already. That's one systemic issue. The second one is irreparable violation of the victim's privacy if this approach is allowed to stand. The third one is the crippling effect on the Commonwealth's cases, because if this approach is allowed to stand and the victims are aware that the defense counsel could be granted to the access of the entire residence and curtilage in case the scene of the crime happens to be inside the residence, that will have and may have chilling effect on the victims in reporting crimes, which will in turn hinder the Commonwealth's interest in prosecuting the offenses. So those would be the three aspects, and I apologize it took me so long to answer Your Honor's question, that this is the issue of systemic importance. But
So you're saying it's extraordinary because once this is allowed, will be allowed again in other cases, and you don't have a means of remedying this because you're the Commonwealth, so you can only come this way.
that is correct, Your Honor.
point?
And also with
Okay, I just want to go back to my original, an earlier question about why isn't it an invasion of the victim's privacy when the jury goes in to look?
that would be subject to the motion to view the crime scene, and at that point the trial will already be ongoing. We do not invite the court to say that there needs to be probable cause to establish that the view would be intrusion on the victim's privacy, because I don't think the view would be a search in the constitutional sense.
But how is it if the defense goes and looks?
And takes measurements and takes photographs.
So you wouldn't object if they were just in there looking? You object to the photographs and the measurements?
On the constitutional grounds, no. On the relevance grounds, yes. Because what happened in this case, the judge, the decision really says it all. She says, none of us right here today can say exactly what will occur at trial. We can make educated guesses about how a trial may play out. The purpose of this is for council to get a scope of the area in which all of this conduct is alleged. If that is not a dictionary illustration to a fishing expedition, I do not know what is, Your Honor.
But the...
She treated this
hold on a
motion as a
minute.
discovery tool, not as,
Hold on a minute. Thank you.
excuse me, Your
Thank you.
Honor.
That's okay. I'm not, so the extraordinary circumstances that you're talking about is that we issue an opinion, if we issue an opinion that it's not extraordinary circumstances, that somehow there's an implication that we've reached the merits. But the case that reaches the merits is Mattis. And Mattis is a strong case for it to be allowed, because, as you know, it's a small apartment, it's 1,000 square feet or something, and
Yes.
there's 8 people in there, and an allegation that rape took place on the couch. So, you know, that doesn't seem like that close a case. If this is not an extraordinary circumstance, that doesn't mean that the court's saying it's okay to go look into bedrooms and bathrooms for prior bad acts that aren't issues at trial. It just says that it's not extraordinary circumstance. It doesn't condone the merits of the order.
Your Honor, I would not want to speculate how the court will approach the case, but I will note in relation to what you just said, and I believe I mentioned this in passing before, all Rule 17 cases, and I know my time is up, so I will be very brief. In all Rule 17 cases that I am aware of, decided in this state, all objects, papers, books, documents were directly relevant to the crime itself. They were all about the crime, the criminal activity, the victim's credibility in relation to the crime. In this case, the defendant is basically urging the court to take this one step further, to say, even if it is not related to the crime, has nothing to do with the crime whatsoever, it's related to a collateral matter that happens, again, God knows when, that is still sufficient. I would say, at a minimum, and this sort of dovetails back to your Honor's question about the systematic issues in this case, at a minimum, that seems to be a very drastic expansion of the scope of Rule 17, to include not only something that's directly related to the crime, but also something that is related to collateral matter in relation to the crime. If the court wants to bless this approach into existence, that will obviously be applicable, that new approach would obviously be applicable to both the defendants and the Commonwealth in all future cases, because, as the court is abundantly aware, Rule 17 does not distinguish between the parties.
That's the merits.
Okay, thank you.
Thank you very much.
Okay. Attorney,
DeMayo.
sorry.
Good morning. May it please the court. Christopher DeMayo for David Pond. We're here today to ask that the court affirm Justice Gaziano's decision denying the 211-3 petition, or in the alternative that the court, if it gets down to the merits, affirms Judge Fryson's order on the discovery issue. Both of these, this is, of course, a case of abuse of discretion, not substituted judgment, so even if individual members of this court might have come down differently, it's not the case that both these two jurists acted outside the realm of reasonable decisions, which is what the Commonwealth has to show here. I'll say at the outset, we don't dispute that Ms. Arsenault, the alleged victim, has a privacy interest in her house. Of course she does, but Mr. Pond is being charged with some serious crimes: strangulation, assault to murder, serious felonies with long sentences. He has interest in a due process interest in putting on a strong defense, a Sixth Amendment interest in cross-examining the alleged victim about, effectively cross-examining her about what happened. So we have competing interests, and when you have competing interests, the judges sort of weigh them and try to come up with a appropriate, fair remedy. And I would submit that when Justice Gaziano got this case last summer and he looked at the order, what you see is a judge, Judge Fryson, trying to balance the interests and trying to come up with a fair remedy. On the one hand, she said, yes, the defense counsel does get to go into the house, which acknowledges the fact that Attorney Jensen needs to be able to educate herself to put on a strong defense for Mr. Pond. On the other hand, she said you only get one crack at it. You get 1 hour. There'll be a police escort, so take all your photos and measurements within that 1 hour, and that's it. So
But that's not what happened.
that's not what happened because she showed up, and three of the doors were closed. And my brother said something about expansion. My understanding was the original order was, Ms. Jensen said, I need to see the doorways, which I took to mean, if nothing else, I need to look into the rooms. But when she showed up, several doors were closed, and there was a police officer there, so she really had nothing she could do except go back to Judge Friesen. So on the face of it, I guess what I'm saying is, this is a case where a judge appears to be considering the sorts of things she's supposed to consider, and she came up with a ruling which sort of takes both these into account. So from the single justice's perspective, nothing really jumps out. Now, I know my brother is saying that there's a systemic issue here, that she said that anytime there's a crime on a private property, you get a defendant and his attorney can view the entire property. I don't think that's really a fair reading what she said. That makes it sound like if the John Adams Courthouse were a private property and there were a crime in this room, you could inspect every single room from the social law library up down. She didn't say that. That's not really a fair reading. Also, this was an oral ruling. It was written down in a margin. So the idea that if she had typed up a kind of formal memorandum of decision that might get picked up on Lexis, you might think, well, this could be cited by other people and cause mischief down the line. But
This is an unusual argument for a warrant in this circumstance. And it just makes me wonder if the court order under Rule 17 weren't the appropriate. Is this analogous to an administrative search more than a probable cause for a crime search? I mean, there's no argument in your first phase of it, I guess. It's the second, but I don't, never mind.
So I mean, I took it to be it's a Rule 17 Mattis type of case is what I'm saying now.
Yeah, that's where it should stay.
And
What's your response that there is state action?
if this is state action, then there's a lot of state action going on in the superior courts, because I mean, this is if you think of all the civil, we're looking at this from the criminal side, but if you think of, you know, Rule 26, Rule 33, Rule 34 of civil procedure, people are constantly being forced to cough up tax records and bank statements and all kinds of things they don't want to do. Is that, maybe it's all state action, but I think this court would be going into uncharted water if they were going to go that way. The last thing I will say in the single justice's defense is, I understood my brother just now to say that Justice Gaziano erred because there was a issue of constitutional importance here because of the state action. But I may be wrong, but my recollection is the 211-3 petition did not mention this whole probable cause state action issue, because I remember, and if I'm wrong about that, I stand corrected. But if I'm right, I don't think that we can really fault him for not recognizing an argument that was not in the petition. So that's my defense of Justice Gaziano. My defense of Justice Friesen is basically that, you know, I think that there were two good reasons here for her to allow defense counsel in. The first general, the second specific. The general one is it's kind of bread and butter defense work to go look at the crime scene. It's required by CPCS. You can be ineffective if you don't do it. Attorney Jensen couldn't be here, unfortunately. She wanted to be here, but I talked to her a couple days ago, and she said she's been in this business since 1981, and she has never not gone to a crime scene. So the idea that
I was a trial judge for 19 years, and I never allowed a motion like this. One reason I never allowed one was I never had one. So it's not exactly happening every day.
well,
And the concern is that it will.
yeah.
And that goes to prong 4 of Lamprey, the fishing expedition.
Well, that's
And Mattis, we were clearly right on Mattis. You had to, the attorney had to be able to go in Mattis to prepare for trial. I mean, I don't see how that could come out otherwise. Sure. This isn't Mattis. This is going into rooms that aren't part of where the crime took place because of prior bad acts that the Commonwealth intends not to offer.
Well, with respect to the Commonwealth, it's really not up to them to say what's offered. I mean, Mr. Pond, the defense disputes that some of these other claims that were made, and they're not like very collateral. These are claims she made to the police and to the grand jury at the same time she was making the allegations that resulted in the indictments. So, and it's our contention that some of these are just implausible. And of course, Attorney Jensen bases some of this on talking to Mr. Pond. And of course, if you're an attorney, you trust but verify. So she believes him, but she wants to see this. And the idea here, and I know Mr. Tretyakov was saying we don't know when this happened, but the idea is that some of her allegations are just not feasible based on where counters are and where cupboards are and where toilets are and which way doors swing and things like that.
Well,
and
well, there's a requirement under Lampron that you can't get the information otherwise reasonably, and the defendant knows where the doors are.
Well, again, it's just Attorney Jensen's going to be the one doing the cross-examination. So to do that effectively, I think she has a professional duty to kind of at least try to educate herself by looking at it's not the same thing talking to people. It's sort of like we had the students here earlier. They could watch this on video, but it's not the same as coming in and having the full effect. And I would submit it's kind of the same idea there. So she had this was not something that was done simply to harass the alleged victim here. This is something that Attorney Jensen does as a matter of course, and in this particular case, she had a reason to go back to the court and ask to look in these rooms because it goes to impeachment of the Commonwealth's key witness. I mean, the whole case turns on this alleged victim. So for that reason also, I would ask that if the court gets down to considering Judge Fryson's actions here, that they find that again, it's abuse of discretion, not substituted judgment, so that even if...
Abuse of discretion on a Lampron Rule 17 motions that happen all the time.
Well, fair enough, fair enough.
And so if that's extraordinary circumstances, what comes before the single justice that isn't?
Well, yes, yeah, that's a point well taken, and that's why it might be easiest just to dispose of this on the first ground about the propriety of Justice Gazianos. But be that as it may, I think Judge Fryson was within her discretion in making the decision she did. She clearly tried to balance the factors this court told her to balance in Mattis. People might disagree, but it was within the range of reasonable alternatives. And those are the main points I wanted to make, unless